Well, good afternoon, Michiganders. It is Tuesday, May 21st, 2024, and of course, this is Tuesday with Tom, Michigan's only weekly internet show where we do answer your questions about estate planning and estate settlement in Michigan. As always, I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, and ambassador for all things good in this great state of Michigan. Welcome to today's program. Well, it's been a little while since I was on the air with you. I've taken a little bit of time off in the springtime, just trying to enjoy the spring weather that we've been having. Also, if you are a subscriber to our office newsletter, you would know that we have, in the meantime, now opened a new office in Grand Rapids as well. So if you have any questions about that office, simply head on over to the Doyle Law PC website and you will find information on the new office. Well, the last episode question, should you use a professional trustee? So you're putting a trust together, you're wondering, should you have a professional involved as a trustee? I encourage you to listen to last week's episode so that you will be better informed in making that decision. Today, I'm going to change gears a little bit. Looks like it's a topic that maybe I haven't covered in a podcast, and that is, do you need a special needs trust for your disabled child? But please remember, what I'm about to discuss during the program is, as always, for educational purposes only. It is not intended to be legal advice. You need to work with your attorney to determine what is appropriate for you and your estate plan. Do you need a special needs trust for your disabled child? Very common when Amanda and I are meeting with clients and they will have a special needs child. That's going to be somebody who's already receiving what we would call needs-based government benefits, such as Medicaid or supplemental security income. The parents obviously are concerned about what options they have to still leave an estate, if you will, for that special needs child and yet not interfere with their ability to receive those needs-based government benefits. So that's what we're going to talk about a little bit today. What sort of trusts planning might be available to you for you consider if that's the circumstance that you find yourself in. And essentially, there are going to be two major types of special needs trust. We're going to have what's called a first party special needs trust, or sometimes called a self-settled trust. That trust is a trust that's being funded with the child's own assets. Perhaps your child has received an inheritance from somebody else, or maybe they're receiving a personal injury settlement or some other sort of windfall. They're disabled, they are receiving Medicaid and or supplemental security income because they have the medical and the financial qualifications to do that. However, if they receive this personal injury settlement or the inheritance, they'll have too much, and that would impact their ability to receive those benefits. So, first party special needs trust, where your child is going to put their own money into it, basically allows an individual with a disability to protect their assets while at the same time maintaining eligibility for those needs-based or means-tested government benefits. If the child is an adult and is otherwise competent to do so, they can create or have created for them that special needs trust without any court involvement. However, if the child is a minor or a legally incapacitated adult, then that first party special needs trust is going to require probate court approval. So kind of two different types. One is where the child is competent, going to have the special needs trust created on their behalf. Second one is where you're now going to require court approval to do that. In either case, assuming that the court approves it, or that otherwise the special needs trust is created and is approved, in that case, it does allow assets to be placed into that trust, used to support, if you will, or assist in the support of the child without affecting their eligibility for the means-tested government benefits. Now, something to keep in mind, though, upon the child's death, any remaining funds in that first party special needs trust have to first be used to reimburse Medicaid for all the expenses incurred by Medicaid during the beneficiary or the child's lifetime. So you don't have an option under this first party special needs trust to determine where those proceeds are going to go upon your child's death. The other type of special needs trust, though, is what's called a third party special needs trust. That would be a trust, for example, that could be created by you as the parent, where you're creating the trust and you are using your assets for the benefit of your child. It's not the child's asset. So the third party special needs trust is probably the most common that we will be dealing with when we are assisting in parents putting together their estate plan. Unfortunately, when many parents come to us, they have been led to believe that the only option that they have for assisting a special needs child, or the only options that they would have, are one, to simply disinherit the child. Don't leave them anything in your estate. And if you don't leave them anything, you're not giving them anything that would put them over the threshold limits that would affect their ability. The second option that many parents are considering when they come to see us is they think, well, if I do want to leave something, what I really need to do is I need to leave it to one of my other kids and have some, if you will, informal agreement with the other children that says, look, we're not going to leave anything in our estate to, let's say, Tommy, our disabled child, but we'll leave everything else to the other kids with the understanding that they will take care of Tommy out of their proceeds. Now, what's the risk in that? Well, the obvious risk in that is maybe they won't do what you wanted them to do. Maybe you would leave the entire estate and they would decide that taking care of Tommy is too much of a burden for them or too expensive for them, and there would not be a legal requirement for them to use those proceeds. That is when you should really start looking at considering this third party special needs trust. Now, the special needs trust that we're talking about can actually be part of your living trust. When we get to the distribution provisions in your living trust and we say, for example, divide the estate up equally between our children, we can then put a provision in your own trust that would say something along these lines. Any distribution that would otherwise be made for our son Tommy will be retained in our trust pursuant to the terms below, which are all the special needs provisions inside your trust. So you don't have to prepare or have prepared for you a separate standalone special needs trust if it's simply your interest in using the proceeds from your estate to have the ability to have them managed for your special needs child. Now, unlike that first party special needs trust, because it's your asset, not the child's asset, there is no requirement that Medicaid has to be paid back at the time of your child's death. That means whatever assets are still remaining in that special needs trust for your child's death can pass to other beneficiaries or charities or wherever it is you would want those proceeds to go. So using this special needs trust, basically inside of your trust, allows you to accomplish your goal of providing additional assistance to your child, while at the same time them not losing their government benefits, and you still having the ability to determine where any excess proceeds go at the time of their death. Now, there's another type, though, of a third-party special needs trust that's going to be a standalone trust. It's not going to be part of your trust. It's going to be a totally separate standalone trust. And when do people do that? Again, it would be not using the child's money. It would be using whoever is setting up this standalone trust. It could be you. It could be a grandparent. It could be somebody else. Essentially, where that standalone third-party trust is going to come into play is, let's say you have other family members that also want to include your special needs child as part of their estate distribution. So let's say grandparents, as an example, look and say, hey, we want to, as part of our estate plan, also provide some benefits, in this case for Tommy, so that there will be benefits available. Well, most of the time, the grandparents don't want to put that money in your trust, because if they put that money in your trust, you can spend it on something else. Or maybe aunts or uncles or whoever it happens to be, where somebody wants to be making funds available, but they don't want to put them inside your trust that already contains a special needs trust. That's the time that you're normally going to look at somebody creating this standalone third-party trust. Now, again, just like inside your trust, there's going to be, obviously, all of these trusts that we're talking about have limitations on what the trust can be used for, because it's by limiting what the trust can be used for that's maintaining the benefit availability for the government, qualifying for the government benefits. But just like that third-party trust that's in your trust, this standalone trust, it doesn't have to be irrevocable. It can be a revocable trust. There's certain people that can create that standalone third-party trust. And upon the death of the beneficiary of the third-party trust, the standalone, again, proceeds don't have to be used to pay Medicaid back. So, again, kind of quick review. Child's own assets, those go into a first-party special needs trust. Your assets that you have a parent, or maybe assets come from other individuals, then you can look at having the third-party special needs trust. Now, there's another type of trust that's called a pooled special needs trust. So, obviously, in having a first-party special needs trust prepared, that's going to require a law firm to be involved in preparing that document for you. In having a special needs trust, the third party, whether it's a standalone or inside your trust, is going to require a law firm to be involved. There is the idea of a pooled trust, and that is where there's going to be a nonprofit organization that already exists, and there are a number of them out there. And what they do is they pool the assets of multiple beneficiaries. So you're not going and having a lawyer prepare a trust to create a trust. There's already one in existence that's being managed by this nonprofit organization. They're pooling the assets of multiple beneficiaries for investment purposes, while basically they're keeping separate sub-accounts for each of the beneficiaries as part of that pooled fund. That's really most applicable if you have a child or beneficiary who have small amounts of assets that don't really warrant the amount of money that perhaps is going to be spent, to have either the standalone third-party trust or incorporating as part of your overall estate plan. And they're looking obviously for professional management and oversight where that's already being provided to them. There aren't trustee fees that are being charged, etc. Now, the advantage of the pooled special needs trust is that upon death of the beneficiary, again, proceeds in Michigan don't have to go to pay Medicaid back. However, they do go to the nonprofit organization. Obviously, it's a means for continuing the work that nonprofit organization is going to do. If you're interested in pooled special needs trust, you can obviously do a Google search and you'll find a number of them in the state of Michigan. They might be related to different conditions that a child might have, or they might be more general where they will manage the proceeds for any otherwise qualified special needs child. Now, there's another option out there. If you don't want to go and have an entire trust prepared, and if the numbers work out for you, there is what's called an ABLE account. And if you already have a special needs child, you might be familiar with that. But essentially, what the ABLE account is, it's a tax advantage savings account. It's basically being treated like a 529 plan in the state of Michigan. If you're familiar with that, we're saving money for college expenses. Similar kind of concept. It's a savings account that's designed to help individuals with disability to plan and save for disability-related expenses. Now, not technically a trust. There's not a trustee. There's not going to be some nonprofit involved. It's not requiring court approval, etc. It's simply an account that's being set up. Now, the account, there are some restrictions on who can actually establish the accounts, and that's all set forth in the provisions for the state of Michigan. But the idea is putting funds, it might be the beneficiaries' funds that are going into there. Maybe they're continuing to work, and some of the proceeds from their earnings can go in there. There are going to be certain limitations, and I'm not going to go into the entire ABLE accounts today. I'm going to save that for a future podcast. But essentially, there are going to be annual contribution limits, which is essentially whatever is the current annual gifting amount. That's going to be the annual limit on how much can be put into an ABLE account. That current limit is $18,000. And if you accumulate over $100,000 in the account, that then could end up causing a reduction in government benefits. So you're going to have annual contribution limits, and then you've got this overall limit that you have to be mindful. But the ABLE accounts, if you're interested and you don't already know about, simply go to Google and look up MIABLE, all one word, MIABLE, and that's going to take you to the link of the Michigan ABLE account, all kinds of information that's going to be available there for you to determine what you're going to do with the ABLE account. Of course, as always, Amanda and I would be honored to have the opportunity to help you protect your loved ones, help you determine what you're looking at by way of special needs provisions. Again, most of the time, we can simply incorporate that into your own special needs trust, assuming it's going to be your assets that are going to be used. We would be happy also to help you amend a current plan that you already have, or put together a new estate plan, or, of course, in settling a loved one's estate. Now you have a number of options. One, we have, as we have for a couple years now, the ability to meet with you at the East Lansing office location. We now have the new Grand Rapids office location on Peninsular Drive, where we would be able to meet with you. Of course, we still offer virtual consultations and by Zoom or telephone. That's how we can probably handle or assist you wherever you are in the state of Michigan. Also, remember, all that information too is available at doylelawpc.com. So if you're interested in any of that, I encourage you to go to doylelawpc.com, where you're going to find information on how to go about setting up these different consultations. Also remember, if you're simply looking for an individual document, maybe all that you need is a new healthcare power of attorney or perhaps a new durable power of attorney, simply head on over to doylelawpc.com and click on the legal store, and there you're going to find information on how you can order simply individual documents through our website as well. Well, I think that's going to be it for today's show. As always, though, if you have a comment about the program, a topic that you'd like to have me discuss, or questions that you'd like to have answered, please send me an email, tom@tuesdaywithtom.com. Also, a reminder, if you go to the new Tuesday with Tom website, you're going to see a microphone at the top along the top menu items. You can click on that and leave a voice message. Again, commenting on the program or asking about a topic that you'd like to have me discussed, or questions you'd like to have answered. Obviously, that's not designed to provide legal advice, but perhaps a general topic that you might be interested in having me discussed. Please also follow us on Facebook. Invite your friends and family to follow us. Again, that is at Tuesday with Tom on Facebook. The office, of course, on Facebook is Doyle Law PC. Remember, too, Tuesday with Tom is available on Apple Podcasts, Spotify, Google Podcasts, iHeartRadio, Spreaker, probably wherever it is that you listen to podcasts, you will find Tuesday with Tom. You can also ask your smart speaker to play Tuesday with Tom. Thanks again for spending some of your time with us today. And as always, I hope that you have an awesome day and an awesome week in Michigan. Stay safe. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.